All rise. The Supreme Court of Guam is now in session. The Honorable Chief Justice Robert J. Torres presiding.
Today, you may be seated. So, today, councils, students, teachers, and administrators from George Washington High School and from the University of Guam. I also greet the members of the general public who may be viewing this series on the Forbes YouTube channel. I'm Chief Justice Robert Torres, along with my colleagues, Justice Anthony Carbolito and Justice Catherine A. Merriman. We want to thank you for hosting us here this morning. May 1st of every year marks Law Day, a national day set aside to celebrate the rule of law and to reflect on how the law and the legal process contributes to the freedoms that we all share. The 2024 Law Day month theme is Voices of Democracy, and it recognizes that in democracies, the people rule, not just them. For nearly 250 years, Americans have expressed their political views and wishes by speaking their minds and voting in elections. In this way, Guam and America ensures that our government remains responsive to the wishes of the people. As part of our annual celebration, the Supreme Court partners with one of the island's high schools and colleges to hold an outreach appellate argument. During this event, students get to watch live arguments in a real pending case, a court hearing, which you can imagine this is not going to be like a trial, like Law and Order, where witnesses take the stand and jurors decide the fate of someone charged with the crime. This is not what you're going to be seeing today. This is an appellate argument. Trials are heard in the Superior Court. When a decision is rendered in the Superior Court, the parties in that case have a right to appeal the decision to the Supreme Court, to us. And an appellate hearing doesn't involve taking evidence from witnesses or viewing exhibits. There are no juries. Instead, the issues are argued by the attorneys who are representing both sides while we ask them questions about the case, about the law, and about the record pertaining to the issues. It may not seem as exciting as Law and Order, but to the parties who these attorneys represent, this is their last chance, their last resort to win the case. So I'd like to thank counsels for today's case, Attorney Nathan Tennyson, who's representing the people of Guam, and Attorney Brad Huseman, who's representing Mr. Towai. We also want to acknowledge the Attorney General who is here sitting at counsel's table. Thank you to both of the attorneys for agreeing not only to argue in front of you, a much larger audience, and perhaps they would have been arguing in if the case was before our court, but also for staying behind and answering some of the questions that you may have. So we will now begin today's hearing, and will the clerk please call the case?
This is Supreme Court Case CRA 23-010, People of Guam Plaintiff Appellee v. Rayland Alfonso Towai, Defendant Appellant. Appearing for Defendant Appellant is Attorney Braddock J. Huseman. Appearing for Plaintiff Appellee is Attorney Nathan M. Tennyson, and also appearing at counsel table is Attorney General Douglas B. Moylan. The panel consists of Chief Justice Robert J. Torres, Associate Justice F. Philip Carbolito, Associate Justice Catherine A. Merriman. Attorney Huseman reserves 10 minutes.
You may proceed, Mr. Huseman.
Thank you, Your Honor.
So have him wait. Yeah.
Yeah. Yeah, there's so much feedback. Well, they're not being. All right, let's try it. Proceed.
Good morning, Your Honors. Mr. Chief Justice, may it please the court. Anybody who has ever watched a TV show or a movie that involves police procedure has a passing familiarity with the Fifth Amendment. Whenever there is an arrest, the police always say the same thing. You have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to an attorney. If you can't afford one, one will be appointed to you. Anybody in the United States has those rights not to incriminate themselves. The Fifth Amendment protects them. We call those Miranda rights. And the police are supposed to advise you of your Miranda rights if there is custody and an interrogation. A few years ago, on the night of Christmas Eve, Mr. Towai was on the property he stayed at, where he called home, and the police surrounded him. He was surrounded by 3 police officers. He did not know that they were there until they surrounded him. He did not invite them onto the property, and they did not give him the opportunity to leave. At that point, they started asking him incriminating questions. He answered those questions. They promptly put him under arrest and then read him his Miranda rights and told him he had the right to remain silent. But by that time, it was too late. He had answered their questions.
Mr. Huseman, excuse me, I've lost my voice over the weekend, but I'll try my best. So before we get into the merits, and appreciate you outlining the facts of the case, I'm a little confused in terms of what standard of review we're going to apply in reference to the arguments in this case. Your opening brief makes reference to a plain error as standard of review, and it's important in my mind. And then in your reply brief, you switched over to a harmless error standard of review. Now, as you well are aware of, that affects the burden of who carries whether or not the verdict was affected in reference to the alleged error that you are arguing. So what is it? What standard of review do you feel this court should apply?
There's several standards of review. I think it's harmless error is for any constitutional error. If there isn't an objection to a particular piece of evidence, then that becomes plain error. If the court views the failure of trial counsel to object to the admission of the incriminating statements, then the failure to object to the incriminating statements goes to plain error, I believe, Your Honor. Otherwise, and the difference between plain error and harmless error, as I understand it, is it switches the burden from harmless error. The government has to prove beyond a reasonable doubt that the entered evidence denied my client a fair trial, whereas a plain error, the burden is on my client. And so the reason there's a discrepancy there, and I wouldn't call it a discrepancy, but it deals with the failure of trial counsel to object to the statements at the time that they were entered against him.
So are you now conceding at oral arguments that it's a plain error review in reference to?
If the court views the failure to object to the entrance to Officer Dodd's testimony as a waived error, then yes, it is plain error.
I mean, do we have a choice? I mean, we're dealt with the facts. We don't make up the facts.
The record is that cake is baked. That is correct. And so to the extent that the court views that, then it is plain error.
Let me just clarify that as well. Because in your brief, you also talked about a Miranda violation that affects the outcome of the trial, could also be viewed as a structural error that demands automatic reversal. but in a situation where there's been no objection, and I think, you didn't cite any cases where Miranda claims were being structural errors and subject to automatic reversal.
Right, and in this case, because there wasn't a suppression hearing, two, there wasn't an objection. I think it's harmless error unless the objection was waived, and then it is plain error.
Now, let's focus on the statements, because I think there are two separate statements that I think you see the complaint about that were obtained from Mr. Towai. One is the statement of his saying, why are you here, the police officers, and you're here because I hit the guy. And then the other, which occurred after he was handcuffed, I'm getting arrested because I hit the guy with that light. So in my mind, obviously, those are the two statements that you're objecting to.
There's also the Officer Dodd asked questions prior to the arrest. So when Officer Dodd testified that when they arrived and they surrounded him on the property, Mr. Choi's first thing to say, well, he's basically in the curtilage of his property is, are you here because I hit the guy? He's surprised someone's there. But then they asked him, I believe the question was, why did you hit him? And did you hit him with that lamp? And so all those two questions also were done before Miranda.
Did he respond to why?
I believe he answered both those questions, Your Honor. Yes. I believe Officer Dodd testified to both those. Yes. And so, but yes, and it's really those, I guess those three things, because in this case, and we're really talking about now the Fifth Amendment problem, which is Mr. Towai is entitled to Fifth Amendment protections if he's in custody and being questioned under this court's People v. Santos case. And in this case, it's clear that he is in custody.
Clearly when he was handcuffed.
Sure.
The government objects to or asserts differently as to whether he was in custody in the initial
Well, the government's position is that this was a Terry stop. And we pointed out that this couldn't have been a Terry stop because it is on someone's property. It's on his property. Now, he doesn't own the property, but he has permission to be there. He has a Fourth Amendment expectation of privacy interest in his home and in the home's curtilage.
So what factors should we focus in that you raise supports that Mr. Towai was in custody for the first statements as you have described? What are the factors? Because the government argues that, well, they argue the Terry stop preliminary questions, but in reference to determining whether he was in custody prior to being handcuffed, because I think that's pivotal in reference to whether he's entitled to the Miranda rights, as you have described. It doesn't appear to have the dominant type police presence as we have outlined in previous cases to support that just the presence in how the officers were assembled made it such that the environment that he was in custody, it doesn't seem to fit in terms of the facts of those cases.
Well, I would say this, Your Honor. So he's in, I guess, what amounts to his backyard, and it's Christmas Eve, and he is surprised by 3 police officers. Now, the police officer's testimony is that they entered the property, and again, we're talking about someone's property here. So if the police are entering, they have one of two things: probable cause or an invitation, right? Or a warrant, one of 3 things. In this case, they didn't have a warrant. I believe they had probable cause. We put that in our brief. We don't dispute that. The police were called to the scene of a fight, and it is what it is. So in this case, he's in the curtilage of his property. The police, one goes on the left, one goes on the right, one goes down the middle. They surround him. And the police testified that they did not give him the opportunity to leave. And so in that case, if we're talking about...
But it's not the subjective intent of the police that it's controlling whether or not your client was in custody. what would a reasonable person believe under those circumstances? Would a reasonable person believe that Mr. Towai could have just picked up and go inside the house? Would he feel constrained that he could not do that under the circumstances?
Well, one, and it isn't clear to me that there's necessarily a house. There's some structures on this property, but it isn't clear to me there's a house. And this goes to the second point, perhaps is why there should have been a suppression hearing. But to your question, I believe a reasonable person on Christmas Eve sitting by themselves in their yard, and their yard is their curtilage, that is sacrosanct under our precedent, on Fourth Amendment privacy concerns. Once they are there and are surrounded by police and being asked why you hit him, and the police have testified that they weren't going to let him leave. They were there to arrest him. I don't know. There's nothing in the record that indicates that they were hiding that intent. What Mr. Towai's point here is today is he was surrounded by police officers in his house. There was no place for him to retreat. And by virtue of that, we believe he was in custody at that point. This court, well.
So assuming that that is the case and that you've established that under those factors, the argument is that he was in custody by virtue of just the presence of the police officers and the way they were assembled there. The testimony, as I understand it, is that Mr. Towai initiated the conversation in reference to making the statements that you have described. And so I guess the issue in my mind were those statements in response to being questioned by the police, or were they voluntary statements that would then take it out of the Miranda requirements?
And I would say that the first statement falls into what you're saying, which is that there's not a question in the record. There is there is a question. It's from Mr. Towai. Are you here because I hit the guy? And I think that goes to your Honor's point. So I think that probably always gets in, with one exception. If at the time they're not announcing their presence, they surround him and they're not letting him leave. They don't have a warrant, but they do have probable cause, and there is a problem there without letting the individual know why you're violating his Fourth Amendment rights to privacy within his curtilage. And the surprise and the shock might cover that. But to your point, Your Honor, I believe that statement always gets in. But what I don't think gets in at that point then is the questions that were asked, right? So as Your Honor's hypothetical goes, okay, he's in custody, but he volunteered some statements. Okay, he did volunteer some statements, but then he's asked, why'd you hit him? Did you hit him with the lamp? And in those cases, that gets in at trial and shouldn't have, I believe, under this court's precedent in Santos.
But we may be getting ahead of ourselves that in reference to the first statement what Mr. Towai volunteered, which was prior to being interrogated. In reference to the subsequent statements, that all had to go with the elements of aggravated assault. And in reference to the simple assault conviction, the statement that he volunteered that he hit Mr. Towai, wouldn't that be sufficient for the jury to arrive at its verdict?
Well, that would be sufficient if the jury isn't presented with different theories. Now, in this case, there were, and this goes to our second point about the suppression hearing, and why he had to take the stand. And so in this case, what you have is a situation where there's basically four main witnesses. There's Officer Dodd, who wasn't at the fight. There was Mr. Towai, who was at the fight. Mr. Takao, who was also a participant in the fight. And then Ms. Gregorio, who's the girlfriend, who was not a participant in the fight and didn't see it. Well, Mr. Takao has memory problems of the evening. And so the majority of the testimony in this case is basically Mr. Towai, either his pre-arrest statements that the officer is explaining, or his subsequent testimony. And so to your point, Your Honor, I think if Mr. Towai doesn't have to waive his Fifth Amendment to explain his incriminating statements at the beginning of trial, or at his pre-arrest incriminating statements, then yeah, there is evidence that there's a simple assault, but there's also the chance that this is a mutual fight, that there's
But let's say we agree with you and that those statements, other than the voluntary statement that was made at the onset, all the other statements, should have been suppressed and were the result of a custodial interrogation. There seems to be other evidence that was there. That was, obviously Ms. Gregorio testified that she was with them. She left the premises while she didn't see the fight. Towai came over and was injured, and she had left him with Towai. Even though Towai had memory problems, and he did testify, and he said he remembered drinking beers and Towai hitting him on the head. Gregorio testified later that Towai had indicated that he had hit her with, used her lamp to hit Towai, even though he disputed what he said. There was conflicting testimony for the jury to weigh, and then they had the doctors who testified that it looked like there was an assault. So, I mean, it seemed like the evidence on the basis of simple assault with the house, he was there, that they were last seen together, that the circumstantial evidence seemed to be sufficient to obtain a conviction. So I'm trying to understand the prejudice that he would have received, even if we said we agreed that there was a Fifth Amendment violation, and we suppressed the statements that he made other than that first statement.
Yes, Your Honor, and that is there is circumstantial evidence. My client's best position on that case is there are other defenses that couldn't be tried because of the information that came in this one. Like there's a mutual fight, mutual agreement to find.
Did he argue self-defense?
Well, no, he did argue self-defense. He did, and in the same way that the jury clearly did not accept self-defense as a affirmative defense in this case, they clearly didn't accept the government's lamp theory either. So,
I mean, I think if he was convicted of the aggravated assault with a deadly weapon with the lamp, I think obviously the prejudice would have been apparent.
Sure, Your Honor, that's
but the jury acquitted him of that charge.
They did, Your Honor, and it's
and so when we're doing a harmless error analysis, even if we found there was error, if the error would have had to affect his substantial rights, so it would be a miscarriage of justice. And
agreed, Your Honor.
I'm trying to understand how it is. I mean, even if we say he shouldn't have testified, we get rid of those statements. How is it affecting his substantial rights?
If he should have testified and he gets out of it, it only really goes to this, and this really is the second issue, which is if there would have been a suppression hearing and if there would have been a way to come up with a better defense that excludes those previous statements, and then it frees Mr. Towai up to present a different defense, one that he doesn't have to testify at. And that might give him the ability to convince a jury of reasonable doubt. And here, if we're talking about that, we're talking about a deficiency in this case, which is ineffective assistance of counsel. And so before I begin with ineffective assistance of counsel, because we have a gallery today, I want to reiterate that when lawyers use the term ineffective assistance of counsel, it's a term of art. We're not saying the lawyer's a bad lawyer. We're not saying that he did a bad job even. What we are saying is that there was some deficiency in the presentation of the case, which happens to all of us. And in this case, the second issue is ineffective assistance of counsel. And to have ineffective assistance of counsel, you need a failure to address some deficiency in the trial. In this case, we think it was the suppression hearing. The record does have a lot of information about what we think are Miranda violations, and those violations should have been brought to the court's attention prior to trial. The jury cannot do anything about a Miranda violation. Only a judge can and do the suppression. And there is evidence in this record of a Miranda problem. And so we think that there was a deficiency there. And we think that did result in an unfair trial, because as I pointed out in answers to previous questions, what we had was a situation where Mr. Towai had to rehabilitate himself. It's a catch-22. Things are being said against his interest that are his statements, and so he had to take the stand to address those.
But didn't he do that knowingly and voluntarily waive his right not to take the stand? I assume that when he took the stand, that the trial judge informed him that he has a right not to be compelled any testimony against him.
I completely agree with you. I think it was a knowing waiver at trial. That is a knowing waiver at trial, and it's a compound problem here, and it's tricky, but this is why we're pointing it out, which is to say, again, most of the evidence in this case comes from Mr. Towai. It's statements he made to the police that get admitted, and then it's his statements at trial where he waived his Fifth Amendment right to make up for the fact and to explain away what his statements prior to arrest were actually about.
So do you think if he didn't, I'm sorry.
No, go
Do you
ahead.
think if he didn't testify, because I mean, I know that your argument is that because they didn't suppress the Miranda statements, he was forced to testify at trial. That if he was not forced to testify at trial to counter the statements that had been admissible and not suppressed, that there would have been a sufficiency of evidence argument? Because, I mean, when I look at the evidence that was advanced by the other witnesses, even setting aside anything that he did, it seemed like there was probably sufficient evidence to sustain the conviction, which goes to the prejudice issue. And
Sure.
So if he was looking at a scenario, if counsel was looking at a situation where there would be a complete acquittal, as opposed to a potential for conviction on either misdemeanor assault or aggravated assault, that he would have argued self-defense or mutual combat. And he apparently chose to go with self-defense, including allowing Mr. Towai to testify at trial to support that theory of self-defense.
Yes, Your Honor. Yeah, it is a problem with the case as it's presented. The record is what the record is, and there are indications that I concede the point that even if we take everything out, there are still problems with the case. And we don't know, because this is the problem with this part. This court in People v. Camacho last year just issued a case on Terry stops and suppression hearings. And suppression hearings work, and this court upheld that suppression hearing. And the problem with trials is you go with the team that brought you. In this case, they had to go with self-defense because of the other things. I think it changed the nature of the case if he doesn't have to testify. I think there were more options that they could have used and would have used. And I can see I'm already over my 20 minutes, and I have 6 minutes remaining. So if there are no other questions, I'll reserve my remaining time for rebuttal.
All right, thank you, Steve. Mr. Tennis?
Chief Justice Torres, Associate Justices Carbolito and Merriman, may it please the court, let me tip this up. The real basis here of defendant appellant Towai's argument is we go to the second issue he raises, which is that of ineffective counsel. That's the premise for everything. The the alleged violation of Miranda rights really stem from this ineffective counsel claim. Now, under People v. Guerrero, 2001, Guam 19, this court has stated that trial counsel is given high deference, a high level of deference in regards to the strategies and tactics they undertake in representing their clients. And in People v. Angoko, 2001, Guam 17, this court has stated that trial counsel's choice of tactics or what they do doesn't necessarily affect ineffective counsel.
But before we address the ineffective assistance of counsel, I'm really confused about your argument that this is in reference to the custody issue. In the first statement that this was described by Mr. Huseman, you argue that Mr. Towai was not in custody because this is like a Terry stop like circumstance. And as Mr. Huseman points out, there was already likely probable cause that a crime was committed and that there's a person responsible that's been identified. That doesn't fit my understanding of what a Terry stop like circumstance is. It's more akin to there seems to be a traffic violation. A police officer pulls up the offending vehicle and then proceeds to initiate certain preliminary questions, the identity of the individual, and to determine whether or not a crime has been committed or is in the process of being committed. That is not the facts of the case in reference to, at least, let's just focus in on the first statement. So do you still contend that these statements come in because this is a Terry stop type circumstance?
So I think the key facts implicated in this particular issue are, this is really a case of hindsight in retrospect of what was known at trial that wasn't necessarily known the night of the incident. So the police had questioned Ms. Gregorio and Mr. Takao as much as they could. He had a broken jaw at the time. And they went to the property. There were no lights. They weren't exactly sure what they were going to find. They knew they were looking for someone who had engaged in the altercation, but they weren't sure. They may have known it as Mr. Towai, but there's nothing in the record to indicate they knew what he looked like or if anyone else was at the property. And when they came upon Mr. Towai, Officer Benavente did first. They were really establishing who is this gentleman, what's going on. And that's when he opened with his initial statement of, "Are you here because I hit Mr. Takao?" And we reference the Terry stop really because it also implicates this concept of police check, public safety. The follow-up questions they asked Mr. Takao, what did you hit him with?
But shouldn't the focus be on factors in reference to whether or not Mr. Towai was in custody when he made the first statement? Not necessarily the preliminary questions, but the circumstance from our prior case law that this is not a police-dominated scene, and it does not support the argument that he was in custody from the get-go, and that the circumstances do not fit that description, and that is the reason why he may not have been in custody when he made the first statement, rather than this is a Terry stop type circumstance, and they were allowed to make these preliminary questions.
So in regards to that, I would note that not every discussion or conversation with police officers is afforded Miranda protection. So Miranda protections apply to custodial interrogations. So in this particular case, there's a dispute as to when was Mr. Towai in custody. The people acknowledge Mr. Towai was in custody upon being handcuffed and taken into custody by the police. Appellant Towai claims that he was in custody as soon as the officers showed up. I think the problem with that position is, if we look at custodial interrogation, custodial one is, does a reasonable person feel that they can terminate the incident or the communication with the police. In this circumstance, Mr. Towai was near the house. He could have retreated into the house. He could have retreated into a nearby outhouse, which also has an expectation of privacy, and terminated that discussion. In regards to
Then doesn't that suggest that Mr. Towai was not in custody before he was handcuffed? And so if he's not in custody because of those circumstances that you're describing, then his Miranda warnings was not required to be issued at that time.
That's correct. You need to meet both the standards, both custody and interrogation. And under interrogation, I believe the standard is direct questioning from the police or indirect questioning that's reasonably likely to elicit a response. In this circumstance, the police came upon Mr. Towai, to which he voluntarily stated, "Are you here because I hit that guy?"
Maybe you can see that Mr. Huseman conceded that the first part of that statement
Mhm,
was a voluntary statement.
mhm.
But in response to the question, why did you hit him? And the answers that followed, absent a Miranda warning since you've already, that those statements were not admissible. Is that correct?
I think the people's position on those particular questions would be that the police were engaging in investigation as to the circumstances. As trial counsel questioned Officer Dodd at trial, "Did you ask anything about self-defense?" And he said no. They were really trying to determine what happened. Is there probable cause here for an arrest? They had reasonable suspicion. I would say it is an interrogation in the sense that there's questions being asked. Yes. Now,
You just said he wasn't in custody.
yes, as to if he was in custody, because we need to meet both of those factors. We need to have interrogation in addition to custody, because those two factors combined create this. Could you repeat, please?
There were 3 armed officers
Mhm,
that had surrounded him. He was lying on the pathway.
mhm.
Do you really think a reasonable person would feel that he would?
So there is some dispute in the record as to how the police and Mr. Towai met. Officer Dodd testified that they found him laying on a table that was on the ground. When Mr. Towai took the stand, he stated that initially the police didn't see him and that he came out and thereafter engaged with them and they were able to see him. So there is some dispute even in the record as to how this interaction occurred. And in regards to the officers being armed, the people wouldn't argue that police officers don't inherently have some aura to them that can provide a compulsion. But in this case, we look through the reasonable person standard. The officers, they hadn't drawn their weapons. Mr. Towai initiated the dialogue, and would a reasonable person have felt able to terminate? I don't know if I'm a reasonable person that can speak to that, but
But there's no doubt there were 3 officers around him whenever that encounter occurred, right?
correct, there's no question. Yes. Now, the appellant Towai raises the argument of, well, if we'd had a suppression hearing, I wouldn't have had to take the stand and testify in my own defense as to self-defense. I think the problem with that is there is significant other evidence indicating that an assault occurred. Ms. Gregorio testified that Mr. Towai informed her he'd hit Mr. Takao with the lamp. Mr. Takao testified that he'd been hit from behind in the head by Mr. Towai. The doctors indicated that there were rather significant injuries to Mr. Takao. He had a broken jaw. The other issue is, and this ties into the hindsight thing I was discussing. We look back in retrospect, what did trial counsel know when he was undertaking his defense of Mr. Towai? He had knowledge of the pretrial discovery, and he had to make an assessment of what's the best way to represent my client. Now, in the discovery itself, there's indications that Ms. Gregorio had given the officers permission to enter the property to take a look, to investigate and determine what was going on. That was never brought forth in a suppression hearing because trial counsel didn't take that approach. And under the high standard of deference that the court provides trial counsel, we would look at, would other competent counsel take that approach?
But what was there in the suppression hearing? It's not presented to the jury, any evidence is gathered. It doesn't have to go to the jury, so how does that make it reasonable to forego a suppression hearing in terms of saying it's strategy?
In this case, I believe, and this is based off of the trial record, trial counsel for Mr. Towai wanted to cross-examine Officer Dodd as to the measures and steps he took in questioning Mr. Towai, interrogating Mr. Towai, and digging into investigating what was the cause of what happened. Was it self-defense? What was the nature of the altercation? And there was that cross-examining of Officer Dodd on the stand. I think that cross-examine would have been difficult if that testimony had been suppressed. And I think that's why trial counsel pursued that strategy, because trial counsel found self-defense argument based on all the other evidence to be a stronger defense, as opposed to just trying to eliminate Officer Dodd's testimony, which was duplicated by at least 3 other witnesses in the evidence. Let's see.
Justice Barbolino asked about the standard of review, and you had put in harmless error in your brief on the standard of review. Is that the standard of review that you feel we should apply?
In this case, I believe it is, and that's pursuant to People v. Rousseau, 2011 Guam 1, where the court stated that if there's a determination of a violation of a defendant's Miranda rights, the standard is harmless error to determine if that violation prejudiced the defendant and gave them an unfair trial. We don't dispute all defendants are entitled to a fair trial. However, in this case, we need to balance the other evidence that was available. This wasn't just a case of Officer Dodd's testimony. It was cumulative of many other witnesses, and the exclusion of Officer Dodd's testimony wouldn't have prejudiced the people's case. They had other evidence that could be inferred that there was an assault that Mr. Towai struck Mr. Takao.
At the end of the day, does it affect the result whether or not we apply the harmless error review as opposed to the plain error review? I mean, I think it goes to the analysis of how we get to the end, but is because it's a higher burden of persuasion in reference to the plain error review, because the burden shifts that it's now the defendant that has to prove that his substantial rights were affected. And so I'm not, first of all, I'm not convinced that it's a harmless error review. I think our case law is clearer that if the defendant does not object, that it's a plain error review on appeal. But do we arrive at the same conclusion regardless of which standard of review is applied?
I think the same result does get reached if we apply the plain error standard of review. I believe we're still looking into the second prong of this appeal, which is ineffective assistance of counsel. What was the basis for counsel's actions, and did it wreak prejudice upon the defendant and give him an unfair trial? I think even with plain error, if you were to find a violation of the Miranda rights and say, well, Officer Dodd shouldn't have been heard, there is still significant and substantial other evidence that the jury relied upon. And the original charge against Mr. Towai was, I believe, aggravated assault with a deadly weapon. The jury didn't agree with that. The jury found Mr. Towai guilty of misdemeanor aggravated assault and gave him a reduced sentence. So there was definitely success in trial counsel's defense of Mr. Towai. In retrospect, I think looking back, the perspective is, well, there was a better option we could have taken, but that in itself doesn't immediately negate trial counsel's determination at the time based on what he had access to.
Right.
The jury had doubts about the initial charges. If officer, I think what Mr. Hughes was saying is Officer Dodd's testimony had not been there and the defendant had to respond by testifying. The doubt of the jury's rights could have extended to the you comment on
Yeah, so I think this ties into the other evidence. If we exclude Officer Dodd's testimony, there's no automatic guarantee that Mr. Towai would not have needed to take the stand to testify as to there being self-defense. There were two other witnesses and doctors who testified as to the damages, the assault. Mr. Takao said he was struck by Mr. Towai. So there is still this issue that Mr. Towai would have had to address even without Officer Dodd's testimony. Now, trial counsel for Mr. Towai tried to get information of self-defense from the other witnesses, but he wasn't successful. Mr. Takao didn't have much information on that. Ms. Gregorio wasn't there to see the incident, just the after effects. And on that basis, I think to pursue this self-defense strategy, which based on the other evidence, even without Officer Dodd, reasonably may have been pursued, Mr. Towai needed to take the stand to get that information out, to say why he acted in his self-defense, what led up to that, because no other evidence could have spoken to that.
I just want to be sure that there was no argument that he was exercising his right to the castle doctrine. It's simply plain self-defense.
Yes, no, nothing under the castle doctrine I'm aware of. My understanding was Mr. Takao was a relative of Miss Gregorio, the owner, had come over for Christmas Eve. The two didn't have good relations, and the incident arose from that. Let's see. With that, I believe I've covered everything I would like to cover. Thank you very much.
Thank you, Mr. Benson. Mr. Hughes, I think you have 6 minutes and 9 seconds.
Thank you, Your Honor. So to Judge Merriman's question, I don't believe there's any castle doctrine issue at all in this case. It wasn't raised below. I do not see it in the record. As far as there was an issue here about probable cause, and the government is maintaining that there might not have been probable cause. I concede that they had permission to enter the property at the time, but I think there's clear probable cause. Again, there's the neighbor, the Good Samaritan neighbor, where Ms. Gregorio or Mr. Takao were at, and he called the police, and they were looking for Mr. Towai. They were told which property to go to, and the way they entered that property makes it pretty clear that they had probable cause at the time and should have made that arrest. As far as the suppression hearing for Justice Merriman, to answer your question, wasn't posed to me, but I don't think there's ever a good reason not to have a suppression hearing. It's before trial. There is no harm. It cuts evidence. It puts the issue in front of the judge. In the civil context, you do the same thing. You put as many papers in front of the judge on this issue as you can to educate the judge as to what the issues are, so there's no surprise. In this case, I think a suppression hearing would have been a very, very, very good idea. There's no harm in it.
What if there was a suppression hearing and Dodd's statements were excluded, any statements made by Mr. Towai also suppressed? How did you expect the evidence to come forward as defensive arguments for self-defense or mutual combat. How is that going to occur?
Well, that changes the. I think I'm off here. That changes the. But it changes the calculus in the case. So, as this court knows, when a defendant is in front of a trial court, that is the one person that doesn't have a burden and a duty. They don't have to say anything. They don't have to do anything. The government, the burden is completely on the government. They have to prove their case. And so in this case, we're talking about a lot of circumstantial evidence. In the case that is in the current record, it's not circumstantial evidence anymore because it's Mr. Towai discussing that evidence and putting it forth. Absent that, it's just circumstantial evidence.
I say, but he said.
That's true. That's true. And so you end up with a situation where, but as I said, Mr. Towai has a memory problem, and it might have very well been enough to defeat the government's burden of beyond reasonable doubt, which is a difficult burden for the government to maintain. And so, as a general principle, all criminal practitioners know it's much better for the client not to take the stand, not to say anything, and to keep quiet at all times, and let the government force the government to prove its case. In this case, Mr. Towai assisted the government in proving its case, and we think he assisted unconstitutionally because of the Miranda violation at the beginning and the failure to have the suppression hearing. If there are no other questions, I think I've maintained what I wanted to say. So.
As I mentioned to you, clearly the jury had probably not having that testimony is how would the defense and the magnify it out to the point that
Well, in this case, you've got a situation where there is doubt. It's a Christmas Eve. There's obviously a fight. There's a Christmas Eve fight. But Mr. Towai's incriminating statements that he has to explain frame, I guess, that fight, as opposed to if those statements aren't there, there's a chance this is just a drunken brawl, and the jury isn't terribly interested in punishing anyone from a drunken brawl. But that is. The problem here is that the unmirandized statements and then Mr. Towai's subsequent testimony really did frame the issue in a way that could have been more nebulous and would have benefited him. Mr. Towai is asking this court to reverse his conviction and give him a new trial. And we thank you for your time.
Thank you, Mr. Houston. Thank you, Mr. Tennyson. The court will take the matter under advisement, will issue a written opinion. And now we will provide an opportunity for the students to ask any questions of counsel or the attorneys. I would just like to caution the students that while we will answer questions, we are not going to be answering any questions, either the attorneys or the justices, about the merits of the case or any specific questions itself about the case, except perhaps preparation. But we can answer questions about the judicial process, about the legal profession, preparation for the case. But in terms of specific questions, the canons of judicial conduct and the code of professional responsibilities prevents us from commenting on pending cases, on the merits of pending cases. So, and I guess we can keep the YouTube channel live during this discussion as well. You can, for members of the audience, if they would like to hear some of the questions that are being asked.
The only caveat is my laptop is showing that I have 10% battery remaining. So if I go out, that's why. It's not that I turned it off.
Is there any questions? I'm sure there's gotta be a question.
I believe I saw an attorney who's practiced law for many years in Guam, is also a professor. I'd just like to recognize Mr. Ogden, who's present.
Ron Evan. Both councils did a great job before us today, and the students, I think, benefited from very good advocacy on the part of the lawyers that are here. And we don't, we choose our cases intentionally, both based on the issues and on the attorneys who are going to appear.
Let me just make a comment while you're all thinking about your very profound questions that you're going to ask us. But while we cannot comment on the merits of the case, I just want to point out that the facts of the case are not fabricated. The court, the lawyers are dealt with the facts, and they must deal with the facts in terms of how it applies to the law. And so Mr. Huseman, our attorney here representing the defendant, Mr. Towai, he has dealt with some very difficult facts in reference to his argument. And so the lawyer's duty is to do the best job he can within the rules of professional responsibility. And while the Chief Justice commented that they did excellent jobs, I just want to point out that that this is not easy, and if you are not dealt with facts that may be favorable to your case, because you have certain rules that constrain you and how you can frame your argument. And you just need to do the best job you can. And that's illustrated really in reference to this case. You may have seen Mr. Huseman squirming up there a bit at times, but that's because he's dealt with certain facts that he cannot deviate from. And that has to do with the very custody issue, the Miranda rights that you hear about on TV. So I just wanted to point that out to the audience.
All right, you can stand up and identify yourself and what school you're from.
It's a question for council. So this is in terms of litigating in front of the Supreme Court versus litigating in front of the Superior Court to make a trial case. What would you have say about the pressure or the intimidation of having being in front of 3 justices versus being in front of 1 judge and a group?
We'll give you both an opportunity to give your perspectives on that, and we'll start with Mr. Huseman.
Wow. Can everyone hear me? I'm a loudmouth, so it works. As far as they're very, very different. So what you saw today is the culmination of what this is how an appeal, a criminal appeal goes for me, right? I get appointed by the court, and after a certain amount of days, the court reporter files all the transcripts. And so in this case, I think it's a four-day trial. That's 150 pages. And then you read through all the motions that were filed, you read through the transcripts, and then you write some papers. And I write 2 papers and he writes 1 paper. And then we make our argument. And that's difficult because as you saw, these 3 justices are trying to poke holes in both sides, and they're not, and I don't want to speak to what they actually think, but my impression of appellate judges is they're not terribly concerned about my client so much as they are concerned with how their rules and the rules they lay down affect everybody. Because at the end of the day, the rules that they issue affect not just Mr. Towai, but they affect everybody. And so they have to be very careful about what they do. And so it's, as you can see, it can be uncomfortable. They ask questions and they're difficult questions. Trial court is completely different. And it's a different pressure because instead of three justices who are asking legal points. You have, if it's a jury trial, you have a jury, and the jury is made up of individuals just like everyone in this room. And it's a service that if you're called on to do it, I would recommend you do it. But when you do that, it's as a lawyer, that's more, I don't want to say theatrical, but you're telling a story, and it's your client's story, and you're trying to put the best story together so that 12 people from all walks of life on Guam listen to it, hear what has to be said. If it's a criminal matter, they say that guy did it, or I don't think the government did its job. That guy, I'm not going to hold him responsible for that. If it's a civil trial and we're talking about money, then the jury's trying to do something that's fair, like that guy owes money. But it's a very, very different system. This is much more. You see the hour we just did. You didn't see the 6 hours I did over the weekend on this case, prepping for that argument, and where my wife asks, who's also a lawyer, asks me a bunch of questions that she thinks they're going to ask. And she missed a few, so I'm mad at her. But other than that, this is a more high wire act, and it's more technically demanding. Where the trial court is, you're telling a story with the evidence you have, and you're developing the evidence in the trial.
Mr. Tennyson, you want to comment on this question?
So as to, is one more difficult than the other? Appearing in front of any justice, whether it be Supreme Court justices, which is a great honor, or a trial judge, which is in the Superior Court, which is also a great honor. They all have the same judicial power investments and receive the same respect and honor, regardless of the level they're serving at. But the two courts are entirely different. I can't add much more to what was already said, but the trial judge in Superior Court is much more concerned with the facts, finding a fair and equitable answer to a pending issue, a conflict between two people. It could be criminal, it could be civil. The judge needs to dig into the facts, apply the law, and find justice. And that's not always easy. The Supreme Court or any appellate court, really looking at broader principles. They're looking at making kind of the golden mean, the golden rule, so that equity can be applied to everyone across many different kinds of cases. So the preparations are a lot different. Supreme Court appellate arguments a lot more condensed. It goes faster than trial court does. Trial court matters can last a year or more. Generally, appeals, are done within a year. And you come in and get to see the fruits of the labor. But there's a lot of late nights. There's a lot of reading, lots and lots of reading briefs, reading cases, distinguishing cases, figuring out why one case says something and another says something else, and really digging into the public policy of it. And that reflects the questions we heard from the Supreme Court justices, really tying into what's a fair application of this rule in broad, not just to the particular facts of this case, but to adopt a rule that can go forward and create equity for many, many, many people. Thank you.
Are there any other questions? All right.
I have a microphone.
Yeah. That would be good. And please again state your name and your story.
Morning, Your Honors. Lenny Hernandez, UOG, under Professor Uggan. Question is, can the court explain the duty of disclosure regarding exculpatory evidence at trial?
I didn't get that. What was that?
Can the court explain the duty of disclosure regarding exculpatory evidence at the trial?
Great. Either of you want to address that? I mean, it's the government. So
Question directed to me.
I think it was a general question.
You know,
Brady material.
question about exculpatory, the duty to provide exculpatory evidence.
Well, I think that our American jurisprudence is not, a trial is not supposed to be by ambush, they usually say. You're supposed to both get ready for trial. Government bears the burden of proof, the burden of persuasion, must get all the jurors in a criminal trial to agree with the government's position, which is the same as the civil cases as well. But I mean, the idea is that you're not supposed to be convicted based upon a good lawyer. You're supposed to be convicted based upon the evidence and the fact that the truth is that you broke the law. Exculpatory evidence goes to that idea that even at the grand jury, when you sit and listen to the evidence before it's green lighted to go to trial, the government has a burden to tell you something that might make you decide that this person didn't commit the crime. So that goes through the entire case for the most part. The defense does not have to prove their guilt or their innocence. They can just sit there and listen to the government make or not make its case. And if after the government presents its case, the defendant believes that they need to take the stand because they think they can convince the jury that they didn't commit the crime, that's when it comes in. So I guess that's one response to your exculpatory. The trials are not meant to be just because you've got a good lawyer that they're going to convict you. It's the good lawyer on the government side is supposed to be fair. We have a duty to see that justice is done. Unlike the defense, the prosecution has to make sure that the case is valid against you. If we know that, and that goes to the Attorney General's prosecutorial discretion, that even if you did do the crime under Guam law, and I'll defer to Guam law, which is the justices sitting behind me, that the Attorney General, because you guys elect that person, can decide this case is worthy of prosecution or this case is not worthy of prosecution. That's part of the check and balances, the idea that an Attorney General should be fair, should be reasonable, but it should also enforce the law. So that idea of exculpatory evidence is giving you the information and not hiding it in your vest pocket, that sort of thing. Thank you.
If I could just add to General Moylan's statement, the principle that applies to all of us involved in the decision making is the ascertainment of the truth. We want to arrive at what actually occurred and what is the truth in reference to what occurred. However, there are certain rules that provide limitations and that may affect how that is arrived at. And so while we have the principle under our rule of law that the purpose of a trial is to find out what is true, there are certain limitations. And in your particular example is exculpatory evidence. The Attorney General's job is not to win at all costs, to hide the ball and to make sure that it is victorious. And that, you know, we've seen the ethics in our Attorney General's office that they try and do the best they can within the principles of law that a defendant is entitled to a fair trial. And the rules that, and one of them being that if there's exculpatory evidence, there's clearly case law that outlines what is the duty of the Attorney General in regards to that type of evidence. And so you try and get at the truth, but there are limitations and it's not to win at all costs.
And there have been appeals where there have been arguments that the exculpatory evidence wasn't provided in advance of the trial to allow counsel adequate time to prepare for trial, and therefore the defendant was deprived of a fair trial. Sometimes it's not the fault of the Attorney General's office. They may have gotten the exculpatory evidence late from the police department on the eve of trial, and they turn it over. But defense counsel comes in and says, I got this evidence too late. The trial judge doesn't grant a continuance, and they've got to go forward with the trial on receipt of the exculpatory evidence at the time that they did. And so, you know, exculpatory evidence, as the Attorney General and Justice Carlito pointed out, is critical to ensuring that the defendant has a right to a fair trial and that it's the ascertainment of the truth. If there's evidence that tends to exonerate or mitigate the defendant's actions, there's a duty, and the Attorney General understands their duty, because they're not to win at all costs, and they have an obligation to the people to ensure that they discharge their offices appropriately. Any other questions? While you're thinking of a question, I'll just comment that the attorneys talked about the amount of time it took them to prepare, not only this weekend, but in writing the briefs, preparing, reading the opposing parties' briefs, and the justices do the same. We all, as you can see, were very well prepared, knew the cases very well, knew the record very well. And that's because we read the briefs that are submitted by the parties. We go through the record, the trial transcripts, as well as the excerpts of records that the parties have submitted. We may do our own independent research. We also have research attorneys that assist us and prepare a bench memorandum for the justices to look at, identifying the arguments that are raised by the parties, some of the strengths and weaknesses of their respective arguments. And so we spend a lot of time preparing for this argument. I'm hoping we can get at least one GW student. I'm not gonna wanna call on one and put you on the spot, but if we can get one GW student to ask a question. If not, we're gonna call in the teacher from GW. Yeah, Justice Merriman wants to make a comment as well, like I'm thinking.
I just want to encourage you that if you're interested in the law, Guam has the Guam Community College, which offers courses if you're interested in becoming a law enforcement officer. University of Guam has its criminal justice program. And there's also other courses in the law offered by the University of Guam. We do not have a law school, but we're fortunate that the University of Hawaii has initiated an outreach to Micronesia and is allowing students to take law school classes online at home, so they don't have the expense of living in Honolulu. So there's a lot of opportunities for those of you who are interested in being involved in the law. Maybe you don't want to go to law school, but the court has a number of professions, as do the Attorney General's office and defense offices, that would give you an opportunity to be a part of the justice system. So if you have any questions about that.
We do have a question back there, Gecko Pride question.
Hi, my name is Jennifer O'Dowell and I am a GW student. And my question is, how do you become a lawyer? And is there certain study techniques that you guys use while studying?
Maybe talk about becoming a lawyer first, and then we can talk about becoming a justice. And I'll actually ask, how many years do you think of education and experience does it take before you can become eligible to be appointed a justice on the Supreme Court? So think about that. If you get the right answer, who knows, you might get a gift certificate somewhere. So lawyers, just answer about the process of becoming an attorney quickly. For each of you, maybe you took different roads and there might be different paths.
So I went to college, the University of Florida. I finished in 4 years. And after I finished, I had a major in history and a minor in secondary education. I then taught school in Miami-Dade County, South Florida. Taught school for 2 years and then went to law school in Dallas, Texas, which law school is 3 years. Once you finish law school, so that's 7 years of total education after high school. And then once you finish law school, you take the bar exam, which might be worse than law school, it's just a test. But then once you get the bar exam, then you are licensed to practice in whatever state you took that bar exam in. So I've taken a bar exam here in the CNMI and in Texas. So I'm licensed in all 3 places. And if you want to be a lawyer, not to discourage you, but it's a lot of reading and even more writing, and then lots and lots of tests. And if you look at it this way, this was a test today too, because they asked me bunches of questions. So it's 7 years of being of school to get to the point where you can have a law license to practice law.
Dennis, maybe explain your background and.
So that was a bit more of a meanderer. It took me 5 years to get out of college. I changed my major 5 times. Everything from microbiology to computer science. I ended up economics. And I took a year off, and I'd always kind of been interested in being a professional, a doctor, a lawyer. Lawyer is what I kind of keyed in on. You get to think a lot. You get to, and for my purposes, get to help people, get to help lots of people. And there's a certain level of respect with the job too. People look up to attorneys, justices more so. And it's a respectable profession. The process was a bit difficult. If you're really interested, the first test you're probably going to take is the LSAT. Don't remember what it stands for, but there's all kinds of books you can study to kind of get test taking tips, and just practice. A lot of the tests are practice. You just have to repetitively do them. Law school was 3 years. Like was stated, lots of reading, lots of tests. The difference there is usually all my classes, you got one big test at the end, and that's what determined if you passed or not. You didn't have little tests in between. You had to read a lot, study, and then do one big long test at the end. And then after you finish that, you get your JD, your Juris Doctorate. You get to start studying for the bar exam. They have all kinds of prep courses. You can do that. And hopefully you pass it the first time. If not, keep trying. You'll pass it. Once you do that, you also have to take an ethics test. The rules of professional conduct are different. Attorneys have to follow the rules of ethics, and they're don't always match up with common sense. You really need to study the rules. Pass the test on that, you can get admitted to a state bar. And from there, you can really go anywhere in the States. I'm originally from Arizona. I came to Guam in December. I'm practicing as a government attorney, and the Supreme Court has been kind enough to allow government attorneys to practice here temporarily, as long as we're licensed elsewhere. So in the near future, hopefully I'll be taking the Guam bar and studying for that again. So
Always study.
yes, always study.
Let me add to, if I may, Mr. Chief Justice, to some of the comments. As lawyers pointed out, you do a lot of reading, so there's a lot of reading requirements. But I think the single most important tool in my mind is your writing skills. In order to be really an effective lawyer, you should try and develop your writing skills. We benefited in this case, we meaning the court, that we have 2 excellent advocates, Mr. Huseman and Mr. Tennyson, with excellent writing skills. And so, I mean, you know, I've been on the bench now for 24 years, and I've had the opportunity to compare, and it's not everyone who can do trial work can be an effective appellate lawyer. And a large part of that is that you may be excellent on your feet in terms of your oratorical skills, and of course that helps. But a lot of the case on appeal turns on the written brief, what is submitted in writing. And I'd just like to conclude by saying that I'm relieved to hear that I spent more hours than Mr. Huseman on Sunday preparing for oral arguments today. So I spent more than 6 hours on Sunday. My wife was not too happy about that, but she understands. She's been around with me. Thank you.
Thank you. So does anyone want to speculate on the number of years it takes of education and experience before you're eligible? Anyone a guess? No one wants to win that gift certificate? Raise your hand and take a guess. Mr. Tennyson and Mr. Huseman gave you part of the answer, potentially. In the absence of any guests, I'll give the answer, and I guess I won't have the opportunity to give away the gift certificate for dinner.
I guess you need to describe where that dinner gift certificate is and how much. That may provide an incentive, and the student just raised her hand.
All right,
Or is that?
7 years is one guess. That's not accurate. But it's a good try, yes. 10 years, that's also not accurate. Yes, we're starting to get some, how many? 6, no?
This is the total number of education and
Experience.
to become a judge.
Yep. 15, no? Yes? 10, no? Yes? Can't hear you?
Whoa.
No? Yes? 18, no? Yes?
Close.
20, no? Okay, 2 more guesses, yes? 8, no? Last one, you get your second guess?
19.
No. It takes 29 years of education and experience before you're eligible to be appointed to the Supreme Court. Of course, you have to graduate from high school, so that's 12 years. And then 4 years of college, 3 years of law school. So that is 19. And then you need a minimum, assuming you pass the bar exam, of 10 years of experience practicing as a lawyer before you're eligible to be appointed a justice on the Guam Supreme Court. So it's a total of 29 years, and I'm sorry you didn't win the gift certificates. Gave you a chance. With that, the court wants to thank the teachers again, the faculty of UOG and George Washington, thank the councils for the argument, thank the students for participating and coming here today. The court truly appreciates every year the ability to go out and do outreach arguments. We hope it demystifies the process for you, as well as providing you a better understanding of what occurs in the Supreme Court, the highest court of Guam, as parties come in and argue their cases, and very important cases for their clients. With that, the justices and the court will now stand adjourned. Thank you.
All rise.